Welcome, everyone. Happy New Year. So as usual, our first item of business is to review our meeting minutes and decision letters from our last meeting. Every commission member should have a copy on their electronic tablet. And as is our normal practice, we'll give everyone about 5 minutes to review those and make sure we do it on the record. So,
I noted a couple of things in review of the minutes and decision letters. On the minutes, on page 5, it should be structures. Instead of structure, it mentions 3 structures. I don't know if typos are that important or not, but also on the decision letter for Miami, Miami is misspelled on the first page at one point.
all right, we have 2 edits. Maybe we can save all of these for one motion. So, anyone else have any other edits? Otherwise, we'll just keep reviewing on the record. So.
Were you saying, Janie, on page 5, why the applicant was proposing 3 structures? What was your edit on that?
I think it's the top paragraph. For some reason mine's not showing up. I had it highlighted in the document. On page 5, first paragraph, 3rd line, it says the plan was changed to 3 structure instead of structures.
Okay, I see that.
Okay. And then on the decision letter for Miami Avenue, the second.
Yeah, I see that too, yeah.
Second line of the second paragraph, full paragraph.
Okay.
Yes. There's an I missing. Since that one was pretty involved, I want to make sure everything is good on that.
One comment that I did have is it possible, since these are very high-level minutes, to add a statement at the beginning that encourages people to watch the video, given the litigious aspect of this case?
Yeah, that particular case.
Tara, is that something that we can add?
You can. I think it's not a bad idea just in general to say that for all the minutes, but it's also known that you can watch the video as well. So I don't think it's bad to not put it in, but I think that it's not a bad idea to put it in, just to be clear that for, the exact record, you can go there.
I know from past experience, litigants will find it and create a written script from it. So. But it doesn't hurt to make it easy for due process.
And on the St. Joseph's, I don't know if that was clear on the last condition, why I wrote it that way. I didn't want it to make it seem like the applicant only had to install 1 buffer sign.
On St. Joseph's, should we specify which end, or does it matter? I think there's signage on the western there's planned signage on the western side of the area, but wasn't the discussion to be that the buffer sign would be on the eastern side so that,
I think it would have ended up on
It'd
the
be more
western
visible.
side, closer to the building,
okay.
from what I remember. That was my understanding. I think
I'm trying to remember.
Jay
the
made the
plans.
motion possibly, but
I don't think the intent was just to where people would have access to walk around it. So the eastern side, I think, had walls that wrapped it. So hopefully,
Okay.
you wanted it closer to the building where they were, potentially drive
somebody
down the
could push
slope.
a mower around.
Yeah.
Okay.
I think it was clear enough to the applicant that it was, saying it at the end was that end, but
Okay.
whatever you want to do.
Okay, are we at a point where we feel like we have the elements of a motion? Yeah.
Logan's got 3 mics.
Yeah, there you go.
I'm not gonna make a motion. I wasn't here, so I'm gonna sit this one out.
Good point.
I'll make a motion to approve the minutes and decision letters as commented on by the members.
I think that's sufficient, since we have that on the record. Is there a second?
I'll second.
All right, we have a motion to second. Any discussion? All right, all those in favor say aye.
Aye.
Any opposed? Any abstentions? One abstention. All right.
So was the decision to add clarification on St. Joseph's, or?
No, they can watch the video.
Okay. All right. That's our primary order of business today, except for, I think the next item of business is to have a discussion about mitigation. And are our mitigation friends here yet?
I believe
Okay,
so.
good. Yeah, okay, there's Mikhail.
How do we want to do this? We've got a lot of representatives from multiple entities.
Why don't we start with the federal government and work our way down?
We have somebody from TDEC that's here, and then we have somebody that we're going to call on the phone as well. So do you want to
Okay.
start with TDEC and then?
Yeah, we'll start with TDEC since they're here in body. Was that you that raised your hand?
I don't have federal.
Okay.
No.
All right. All right, Adam, if you want to come on up to the mic over here on the right, we have to put you in the light and put you on the mic so the recording can catch you.
I'm going to call Mr. Lee Barber as well.
Okay. And he's with the Corps.
He's with TDEC as
Oh,
well.
with TDEC as
We don't
well.
have anybody from the Corps.
We'll holler at you in a minute, Mikhail.
Well, do we want to have all of them just come sit and it can be more of a discussion?
Yeah,
That's kinda what I
yeah,
thought.
that'd be fine too.
Mikhail, do you want to come up?
Yeah, that'd be fine. We'll just create a mitigation panel here.
I think we'll
Whichever.
All right, that sounds great.
And then we've got representatives from Metro Parks and Greenways.
Are the Greenways and Parks folks here?
Yes.
All right, if you all want to come on up, yeah, just come on up.
And then,
Sorry to put you in the open like that, but it'll just keep us from having to bounce back and forth. Yeah, yeah. So are we gonna have a Corps representative, or did they say they
I
could?
didn't get.
Okay, all right. Okay,
We're going to get started in just a second. Okay.
so we got one other person we need to patch in by iPhone and microphone.
Is he on speaker?
He is on speaker. I think he'll be able to be heard.
I was wondering if any of the other mics go on.
See if I got a book.
That one might go lower. That's what I used this morning.
Yeah, that one will go lower. Mine will go lower.
Can you hear us, Lee?
Yes, I can. Can you hear me okay?
Yes. Can you, everybody in the room hear him okay? Turn his sound up a little bit.
Yeah, I'm not sure how many people there in the room or who I'm not hearing. I'm hearing a couple of voices.
That's great.
And do we want to also have somebody from Home Buyout Tom Palco or somebody to talk about those properties for this discussion?
I think so, as needed. I think we're out of chairs, but,
We might be able to pull one up to the side.
yeah.
Okay,
Okay.
okay.
I think Mr. Palco's earned the right to decide when he steps forward. All right. Okay, so, why don't we start with, I never had so many microphones in front of me. All right, why don't we start with our TDEC, why don't we start with introductions first? Let's have everybody introduce themselves, and then we'll start with our TDEC host.
I'm Mikhail Houghton, Executive Director of the Cumberland River Compact, and we run an in-lieu fee compensatory mitigation program in addition to non-regulatory stream restoration projects.
Okay, excellent, thank you.
Good morning. My name is Adam Kelly. I'm with TDEC Water with the ARAP program.
All right, thank you,
I'm Tim Naich. I run the planning division at Metro Parks.
thank you,
Hi, I'm Cindy Harrison. I'm in the Greenways Division at Metro Parks.
thank you, Cindy. We know Mr. Palco. Would you like to introduce yourself? Lee Barber?
Good morning, everyone. My name is Lee Barber. I'm the manager of the Natural Resources Unit in the TDEC Division of Water Resources. I manage the program that handles aquatic resource alteration permits, and I work with Adam in this unit.
All right, so you want to kick us off and just tell us a little bit about, your role in mitigation, what you expect in the future. Maybe tell us a little bit about the situation with the Tennessee Stream Mitigation Program that is currently in a state of reorganization. And I don't know if you have any prepared slides or you just want to do this verbally or just, we're informal today, so.
No, I don't have any prepared slides. Okay. So, yes, I'm happy to answer your questions on those topics.
All right.
And Adam, I can't see you, so feel free to chime in. But just to clarify, this was a conversation I had with Logan. So when you talk about the Tennessee Stream Mitigation Program, I just want to clarify that there was an organization by that name that still exists. It's had its challenges, and those challenges are being addressed through the Army Corps of Engineers. Are you asking about that entity and that program, or are you asking simply about stream mitigation in the state of Tennessee?
Both.
Yeah, I think it'd be helpful just to clarify why we were hoping to have everybody involved. Is mitigation's a big component of our approvals, and just because something's required, we're looking for above and beyond mitigation. So we're looking for opportunities where our applicants can come to y'all where they normally wouldn't have to, and to try to figure out if there's any kind of synergies or how we can keep this mitigation in Davidson County instead of them having to go outside of Davidson County. But it just seems like there's a lot of hurdles that may exist for reasons, or maybe we can kind of break down some of the barriers and really let our applicants bolster your goals.
Okay. So I will offer this. The Tennessee Stream Mitigation Program, because of its inability to fulfill its commitments, is now undergoing some legal discussions with the Army Corps of Engineers. For that reason, it is not really appropriate for TDEC to discuss that. It is in the hands of the Corps of Engineers. There will be, I think, a couple of projects initiated to try to address some of the shortfalls, but those are going to be to address commitments that TSMP had already made and not fulfilled. So it's not going to be any additional stream mitigation credits available to the community. It's a partial fulfillment of obligations that they incurred and have not yet fulfilled. The Board of Water Quality, Oil and Gas received a briefing on that. But I guess the takeaway message is that's kind of out of TDEC hands, and it's really, other than just answering very general questions, any specific questions about the future of that organization and the mitigation it may create and put on the ground is more properly directed to the Corps.
So
because there's some legal issues there, and it is the Corps of Engineers that is handling that.
So it's fair to say they're not going to be a viable option per Jay's question.
Correct. They are no longer considered to be a mitigation provider in the state of Tennessee. Going forward, it will simply be a matter of whether they are going to be able to put projects on the ground to fulfill any of their pre-existing commitments that they haven't yet fulfilled.
Okay. So just to give everybody a recap of that, the reason we were interested in the TSMP is that it for better or worse, it set a bit of a precedent for mitigation banking in Tennessee. It was created 2 or 3 decades ago to provide an outlet for the Tennessee Department of Transportation and others to pay a fee that basically was based on a linear foot payment. I think it started off being $200 a linear foot for streams and stream buffers that were affected by bridge crossings. You would pay into this fund based upon the number of feet that you disturbed, and then a regulatory panel made up of the state and the federal government would decide how those mitigation credits would be accounted for. They would go out and contact either public or private landowners, and then they would, through a process of legal agreements, set up a mitigation bank, sometimes impromptu, sometimes in preformed mitigation banks. They would use that money to purchase those credits or to create those credits on the ground. And then the mitigation would stand for some ratio of either 1-to-1 or 2-to-1 or 3-to-1, or in some cases 10-to-1 replacement of the amount of either wetlands or streams that were affected by that previous construction activity. So over the operation life of that program, it's come to light that that they had not been able to meet their mandate. They have quite a few mitigation credits that have not been able to be realized on the ground physically as restored replacements for lost wetlands or feet of streams that have been impacted by stream crossings or other types of construction and development. And it's going through a whole process of reorganization. So I guess one of the things we'd hope that we could do today was to kind of learn why that didn't work and how not to make those mistakes again in rethinking how this might go forward. But it doesn't look like we're going to be able to go very deep into that story or why it didn't work. So, where it's appropriate, if the various panelists that are here today, if you want to comment on how your maybe previous interactions with the TSMP generated broad lessons that we can learn from. You don't necessarily have to cite anything specific about the program if that's not legally appropriate to do so right now. But if you want to reflect on some of those lessons learned, that'd be great as well. So,
yeah, this is Lee again. Yeah, I would like to offer that to help Metro understand the mitigation environment in the state of Tennessee. It's probably more useful to talk about the federal mitigation guidelines that came out in 2009 and mitigation requirements under state of Tennessee law and rule that came out in 2019, because those are really what set the foundation of the current mitigation environment in Tennessee.
Okay.
The Tennessee Stream Mitigation Program, again, that was not affiliated with the state of Tennessee. It was just an organization that happened to do work within Tennessee. But that's is part of the history, and it is true to say that the mitigation environment in Tennessee as it currently stands was probably strongly influenced by how that entity operated. But in terms of helping Metro, figure out how to address the mitigation requirements for projects within Davidson County and outlying areas, it's probably better to talk about the federal mitigation guidelines, the functioning of the interagency review team, of which the Corps of Engineers and TDEC are co-chairs, and then the mitigation requirements that were established by the 2019 updates to the ARAP rule, Tennessee Water Quality Control Act, stream mitigation guidelines, et cetera. Because Tennessee stream mitigation program is part of the history, but really there is nothing about that program that determines current mitigation requirements going forward.
All right, so do you want to address those points?
So first of all, I didn't hear all of the introductions. I heard that Cumberland River Compact has representatives. Is there anyone from the Corps of Engineers participating in the meeting?
No, they weren't able to come. We do have some folks from Metro Parks as well.
Okay.
And Metro Greenways.
Okay, and then when I spoke with Logan about setting up the meeting, he mentioned the possibility of discussing mitigation for projects at the airport. Is there something along those lines that we should discuss, or is it just mitigation in Davidson County in general?
Yeah, why don't you go ahead and address both, because, the first one relates to sort of future actions of this commission. The airport references a commission variance that we approved last year.
Okay. So very broadly speaking, and I'll try to focus on law and rule for Tennessee, but since the Corps is not present, I'll try to provide information on that, an overview of that, but they probably should really speak for their own program at some point. So broadly speaking, there were the 2009 federal mitigation guidelines that determine how mitigation across the country and within the state of Tennessee functions in particular. There is an entity called the Interagency Review Team, which is co-chaired by the Corps of Engineers, Nashville and Memphis districts, and TDEC. Other participants in that review team are EPA, primarily representatives from Region 4, Tennessee Wildlife Resources Agency, Natural Resource Conservation Service. Adam, who else is on the IRT?
The U.S. Fish and Wildlife has a representative.
U.S. Fish and Wildlife.
Does TWA still have a representative as well? Okay.
So these are all entities that provide input, but I will say that it is, depending on the project, it is primarily TDEC and either the Nashville or Memphis districts or the Corps of Engineers. So just to make sure we're on the same page, Tennessee Stream Mitigation Program was a mitigation provider. Their projects had to be reviewed and approved by the IRT. That process still exists. There are many other mitigation providers in the state beyond TSMP. So please don't think that because the TSMP program is kind of defunct that there are no other options. There are many, many strong mitigation programs carried out by nonprofit and public entities in the state of Tennessee that provide mitigation credits through both stream and wetland impacts. So the program is growing quickly, and it is well on its way to being very robust. The challenge is that the ability to provide mitigation credits in the rapidly developing urban areas is hard for anyone, nonprofit or private entity. It has to do with land prices and things of that nature, but to some extent, it's just the pace of the development. It's happening far faster than projects can be identified and put on the ground. So that's probably what development in Davidson County is providing as the major hurdle. And under Tennessee law and rule, mitigation is a third-party market-based process. So the state, TDEC, Division of Water Resources, is not involved in creating mitigation banks or providing mitigation for projects. There are other state agencies, TDOT being the main one, that get involved, but as a regulator, the TDEC, Division of Water Resources, does not provide mitigation, and the monies that go towards mitigation do not come to TDEC, Division of Water Resources. I'm having to split hairs a little bit because there are some things in the works. We're historically an organization called the West Tennessee River Basin Authority, which is administratively part of TDEC, but reports to a separate board. They do create stream restoration projects that generate mitigation, and they're playing more and more of a role, particularly with regard to providing assistance to TDOT. And there have been a couple of projects in the past, both in-lieu fee programs and mitigation bank proposals that have been presented by West Tennessee River Basin Authority. We think there are going to be more in the future, but they are just one of the players across the state of both nonprofit and private sector entities that are providing mitigation credits. Now, the one other option I want to discuss very quickly, because I think it's going to be the basis of a lot of mitigation in and around Davidson County, is what we call permittee responsible mitigation, which is pretty much what it sounds like, where the applicant who is having the impact identifies a project site and either conducts the mitigation restoration themselves or subcontracts to another entity. But it is the applicant permittee that is on the hook for the success of that mitigation. The appropriateness of the proposed mitigation is evaluated as part of the application process. The appropriateness is based on the type of resource replacement and the location within a watershed. We have some guidelines about how far away a watershed restoration project can be conducted relative to the point of impact that influences whether we accept it as a replacement for lost resource value. But generally, I think PRM may very well be a big part of mitigation within Davidson County, just because there are not a whole lot of options available. And now I'm going to put Adam on the spot to see if he would like to offer any more comments on PRM, how we evaluate it, the type of information that we collect from applicants for PRM projects.
Yes, PRM is definitely an option and, in fact, oftentimes a preference of TDEC when it comes to an applicant or a permittee providing compensatory mitigation to offset unavoidable impacts to aquatic resources. That's an option for all applicants statewide. You know, that's developers, sister agencies, metropolitan governments. There are requirements for that PRM. Any functional deficiencies within the watershed, stream channels, wetlands, those functional deficiencies need to be addressed through restorative action. So it's not just going out and planting trees on a deficient channel. You really need to address in-channel instability, fix geomorphological problems, and then ultimately, once all that restoration takes place, that site has to be protected in perpetuity. So no getting in there and managing vegetation, no getting in there and constructing maintenance buildings or doing anything that's going to jeopardize the ecological value or stability of that site in perpetuity. So that's an option. But those are the standards that TDEC and the Corps are going to hold applicants to. Fix the functional deficiencies and then protect it in perpetuity.
So it sounds like since these are regulated by essentially ARAP permits, correct? You all have a much broader authority than, say, our commission normally would. We're primarily focused on the buffer. You all are focused on the buffer as well as in-stream ecological function. And so is that the reason why the nature of perpetual agreements is so critical? Because I know that's one of the stumbling blocks for other public land agencies to typically be a partner. Metro Parks, I'm not speaking for you two individuals, Greenways or Parks specifically, but we've gotten word back from Metro Parks that's one of the reasons why they've had a hard time agreeing with some of these mitigation banking proposals that are associated with ARAP permits in particular, that it ties their hands in perpetuity up for maybe potentially putting in a bridge for, if it's like a golf course where they may be considering doing mitigation banking to bring in some revenue to create some new kinds of habitat or some new kinds of landscaping associated with that mitigation. Now they can't touch that site ever again, so.
Well, there's definitely some nuances there. And yes, we've been involved with parks in particular associated with some mitigation PRM proposals for improvements in Alejandro. And so, both Adam and I are familiar with some of the challenges that go with that. So and tell me if I'm getting too far down in the weeds, but there's a couple of nuances there. So with regard to protection in perpetuity, it is generally considered under Tennessee law.
Please speak up.
Sorry?
Please, you need to speak a little louder for us. I'm sorry. This is an important topic.
I can increase the volume too. All right, go ahead.
So with regard to the actual sort of real estate aspect of protection in perpetuity, it is generally considered that ownership of the property by a government entity fulfills the requirement. But there will also, in addition to the ownership or control of the property, there are also associated land use restrictions. And yes, those land use restrictions will require that the resource that is being used to offset impacts to another resource cannot themselves be impacted. And so, because otherwise, you lose, the resource that is being worked on. And I'm just going to use the Shelby Bottom sites as an example, because it's one that many folks in the room will be familiar with. If those streams are used to offset the impacts to the stream at the Alejandro site, they need to remain in a natural condition. Otherwise, they are not a replacement for lost resource value. And so that's why what can be done to those resources going forward is very constrained, because not only are impacts associated with, say, a small stream crossing, a small bridge or something like that, are impacts to the resource directly. It is sort of taking out the resource replacement that was supposed to offset the impacts at the stream at Alejandro. And so it's almost, double dipping from the standpoint of an impact. And so I hear what you're saying in terms of the way that the land use restrictions constrain the ability of a municipality to use land to provide mitigation. But those are constraints that are necessary in order to protect the resource value of the mitigation site. And so while we can take them into account on the front end and identify what those areas are and exclude them from credit generation, it's kind of non-negotiable that the resource not be impacted, because otherwise it's not a replacement for lost resource value. And in fact, it is itself an impact. And so that's where that comes from, is that in order for a restoration to be considered a replacement for lost resource value, that resource has to remain, not subject to direct impacts from stream crossings or removal of riparian vegetation or what have you.
So in other words, it sounds like you can break down these sites into segments, into maybe smaller stream segments, to where some segments can be, say, ineligible for mitigation, and other segments can be eligible. So the trick would be if say, Metro Parks or Metro Greenways were managing property that they wanted to consider for a mitigation bank, they would need to make some perpetual decisions about which stream segments they want to preserve for the future for, say, a golf course bridge crossing or maybe an expansion of a T area or something like that, and which areas they definitely know or feel very confident that they would never use. Because it sounds like the opportunity for both sides of the equation here is, one, for the public to get a net gain of resource that was lost. That's always a bottom line. It's got to be a net gain that will always be there because we lost a resource. We allowed someone to develop it. We gave them an area permit, or we maybe gave them a variance from this commission. And we've lost the function and value of that resource. And now we're trying to mitigate that with some kind of net gain. And it won't be a net gain unless it's perpetually there, unless it's perpetually set aside.
It's certainly a replacement. So the phrase that tends to get used both by us and particularly by the federal government is no net loss. Okay. So the way we assess the impact is we're simply looking for a replacement of lost resource value.
Yes.
And we have some technical ways we calculate that. So the purpose of a mitigation project is to replace the lost resource value. It doesn't necessarily need to result in a gain relative to the original resource. It simply has to replace what was lost. And then, like I said, we've got technical ways. There's a tool called the debit tool, the stream quantification tool, that we use to assess that for streams.
So so for example, when you're requiring like a 2-to-1 or a 3-to-1 or a 10-to-1, as I remember from many years ago being associated with the Tennessee Wetlands Conservation Strategy, you're not really saying you're trying to get a net gain. You're just trying to ensure you'll have a success to replace the resource that was lost.
Correct. Replacement of the resource that was lost. And part of the reason I mentioned that kind of the basis of our discussion needs to be the current federal guidelines and the current state law and rule is because we no longer use the ratio-based system for assessment of impacts to streams or for mitigation. It's a quantitative basis. It is required under rule to be a quantitative basis. And so we talk about rather than a ratio, we talk about functional feet.
Oh yeah.
And that's where the SQT, the stream quantification tool, comes in, because it allows us to take into account the fact that a resource, even before the impact proposed, is not going to be pristine. And so it's a comparison of the current status of the resource relative to the proposed status, and then figure out how much resource value is lost. It does not assume that the resource was pristine to start with.
So that's kind of analogous to doing a tree inventory on a city site for developers. They go out and they count the number of trees. You all go out and count the ecological functions and structures that exist out there right now. And that way you're only replacing what's there versus what ideally should be there.
Yeah, and it's always subject to constraints of time and money. And so, I'm a aquatic ecologist. And so I always try to make a distinction that we're not really talking about ecology. We're not doing a full ecosystem assessment. We are talking about environmental regulation. And so, yeah, SQT is a way to assess some of the functions of the system, and it's the one we use. So, there's a little bit of a distinction between the true value of the resources versus the way the value is assessed under law and rule. But the applicant, the permittee, really only needs to worry about, the ARAP way of assessing, not some bigger picture ecological study that would take 20 years to complete. They just have to fulfill the requirements under law and rule for assessing the current condition and the proposed future condition.
So let me see if I can recap real quick so that we can open it up to questions about this particular topic for other commission members. But the one recap is it sounds like you all are somewhat bullish about the possibility of mitigation banking to be successful in the state.
Yes, that's true. I think we can make a good argument that it is. And that's why I think it's important to kind of disregard the Tennessee Stream Mitigation Program as any kind of an example for the current status of mitigation in Tennessee.
Okay.
There have been a lot of projects. Adam, do you have any number of the ballpark? I know Ross was pulling together that list, but I would say there's probably been
I'd say
60,
lead
70, 80 projects just in
Exactly.
kind of the last
Yeah, over
5
the-
years, maybe?
over the course of the last 5 years, projects that are in C2 being proposed now, projects that are approved and providing mitigation to the development community, I'd say there's probably over 100 sites, site-wide mitigation banks that provide that service.
And how many of those are in Davidson County?
One or two,
Out of the, how many total?
100 or so. And of course, that's dependent upon land prices, availability to dysfunctional streams, and being able to fix those up.
So I guess the first point I was trying to make for benefit of the future chairman is, is that one is working outside of Davidson County. We have a limited number, which is why we called for this discussion. We have too few opportunities to provide applicants, to point applicants to in Davidson County. The reason why we have too few in Davidson County, because it's a rapidly developing area. Land prices are high, and land property owners have various concerns about perpetual agreements in various aspects of tying up portions of their property that they may feel like limit their property maybe in ways that they don't want to limit it. So it just makes it harder. But the fundamental point here that I think we have come to that's totally different than the past and totally different than the shadow that the Tennessee Stream Mitigation Program was sort of implying was a trend, was that mitigation banking is working elsewhere. And if we want to figure out a way, every generation is tagged with a hard problem to solve. And this is one for the younger folks coming up in Davidson County to have to work out. There is an opportunity for this to work in Davidson County because it's working elsewhere in Tennessee. We've just got to figure out how to make it work. So are you satisfied that we understand everything we need to know about this particular topic from these two gentlemen before we move on to the discussion of the airport?
I think this moment is opportune. I heard three things from Mr. Barber that make that point valid of the opportunistic moment. One is the Corps and its legal team is re-looking into how this program is structured. Did I hear that correctly, Mr. Barber?
I'm sorry, I didn't catch the last part of your question.
The Corps is currently revisiting the structure of this program.
So I wouldn't say it's being revisited. I would say that it has been updated since the Tennessee Stream Mitigation Program that we were discussing. So the federal guidelines were revised in 2009. Those are the ones that the federal agencies are operating under. And then TDEC's law and rule was revised in 2019. So what we have currently with regard to mitigation requirements is, there can always be, things happening at a federal agency level or in the state legislature. But in terms of mitigation being within Tennessee being restructured from the way it functions now, no, we're not really seeing anything on the horizon other than additional mitigation projects being implemented under the current guidelines. This is, to be a bureaucrat that complains about the workload. We are getting so many mitigation proposals coming through the IRT across the state that it is a very real challenge for my staff even to be able to find the time to reviewing the proposals and doing the site visits. So I would say the program is strong, and there's new proposals coming in to the IRT weekly, and there will be a lot more credits in the future available than there are now across the state. But there are no real, that process isn't likely to change in the near future. But I will agree with you that Davidson County, just because it's so built up and not very many sites that would be suitable for mitigation, the availability of mitigation in Davidson County is going to continue to be a challenge. But the one point I want to make, in case mitigation for a project in Davidson County doesn't necessarily have to be within Davidson County. We don't look at county boundaries, we look at watershed boundaries. And we do allow mitigation to occur outside the watershed where the impact is. We have to do that assessment of replacement of lost resource value. And so generally speaking, the further away it is from the site of impact, we're going to have a multiplier based on the number of watersheds it is away. It needs to be a resource of a comparable type. But I don't want anyone to, come away to think that all impacts within Davidson County can only be mitigated within Davidson County. It is far better if they are, and that's why Adam mentioned that TDEC actually sometimes prefers permittee responsible mitigation because those PRM projects are often conducted closer to the point of impact, and that's our priority. But then the other thing we haven't really spoken about is the Corps of Engineers. And so for projects that impact waters of the U.S., that's really a separate set of mitigation requirements. We do a really good job, I think, of, coordinating so that what TDEC asks for is very close to what the Corps asks for and vice versa. Sometimes there's, but we do have different jurisdiction. Waters of the U.S. is sometimes a little different from waters of the state. And then sometimes our mitigation requirements are a little different based on that. But in general, we work very hard to keep an applicant from getting stuck between the Corps and TDEC. We work really hard with the Corps to coordinate to make sure the mitigation satisfies both entities.
Does anybody else have any other questions?
Let me try to frame this up because we're getting into the nitty gritty on some of these details, and I think that we need to state the problem. The problem is that as what I'm calling, we've experienced several cases come before this committee that are public infrastructure related. These public infrastructure projects are within dense urban neighborhoods. One would be the airport. Another one that we received a preview of is the Omohundro. It's in East Nashville. The airport, for example, encapsulated a significant portion of Sims Branch Creek. Their compensatory mitigation proposal came before this committee and said, there are no opportunities on our property. There are no opportunities within Davidson County. And we will search for future opportunities once we apply for our final grading sign-off. The airport came back to us after the project was completed and said, we are unable to get a grading permit sign-off because we've been unable to fulfill our original obligation for the compensatory mitigation program, and therefore we would like to revise that proposal and purchase credits that are outside of our watershed. Please correct me if I'm incorrect in any of those facts. What's happening, and what we do not want to have happen again, and Mikhail, can you give us a ballpark dollar amount for how much those credits cost to go out of watershed?
That's a multiplier applied by TDEC and the Corps of Engineers. I'm not sure out of watershed.
Give me a rough guess of how big that check was.
Oh, from the airport? It was a lot.
Is it 6 digits? Is it 7 digits? Upper 6 digits?
6, yeah.
That's just one case. There are millions of dollars being spent as part of this program within our ever more so densely developed Davidson County that are benefiting rural areas that are causing, and I'll say, flooding in our neighborhoods because this program, I feel, needs to be tailored to serve the community in which the impact is occurring. And the problem that we're having is the red tape due to the perpetual easements. And I'm going to put a pin in that and come back to it because I have one more question for Parks. Mr. Ness, how many acres of parkland exists in Davidson County?
18,000 plus.
18,000 acres of undeveloped property exists in Davidson County.
That's not undeveloped, that's total acreage.
Total acreage of parks property within urban neighborhoods. There is also another portion of acreage that exists that is owned by Metro, and that is Metro flood buyback properties. Is anybody here that can answer a ballpark amount of acreage we have of Metro flood
Mr.
buyback
Palco
properties?
had to leave.
Mr.
Mr.
Palco had
Lindsay,
to leave.
no.
Mr.
Too many
Lindsay.
buttons. Obviously, that number exists.
It does, and I'm sure it's a 4 or 5 digit number.
I think we've purchased 435 properties for demolition. That dates back to before the 2010 flood. We started buying properties, many of them in the North Davidson County area. Goodlettsville, south part of Goodlettsville, I think, is where we began to purchase those early properties, and then maybe fewer than 100 before 2010, and then hundreds of properties since then. I report that number in terms of acreage in our annual CRS publication, but I don't have that number with me today. So
That's okay, but in essence, there are tens of thousands of acres in Davidson County. There are hundreds of thousands of dollars being spent as part of this program going outside of Davidson County because of the reason that we've heard from administrators of this program that say that there is no opportunity for mitigation in Davidson County, and I think that is false. And the reason why we cannot come to an agreement with performing this work within county is because of the perpetual easement. So I have a proposal. And the proposal is, and maybe we need to work with state legislature or other entities, there should be a process by which a variance can occur for mitigation efforts, or mitigation work that was done previously on a property such that a park's bridge needs to cross that stream, or maybe they need to build a nature center that is within the buffer, or maybe even a greenway that needs to encroach into that area that was once mitigated. But if we can replace that section of mitigation downstream or upstream or within at least the same watershed, then we are still achieving the same goal by mitigating the impact that was done previously. We have a real big opportunity here to fulfill, I believe, the mayor's office objectives of fulfilling our plan to play in our Connected Greenways program through these dollars. Let's make this opportunity for not only mitigating flooding, but a public benefit. A lot of these dollars, again, can go towards greenways. A lot of these dollars can go towards maintaining the under-maintained Metro flood buyback properties. And so I just feel like when we send these dollars down Swamp Road in Pulaski, Tennessee, in a rural cow pasture to do mitigation work, it's really not doing the taxpayers service. It's really not doing the community that was impacted service. It's really doing a disservice to those parties. And that is why I feel we need to really start making a pivot as we enter new Nashville second act of our next boom era to make sure these pieces are in place. We have a giant project on the river about to unfold, and they're going to be purchasing credits. So let's get ahead of this and get some policy in place so that this committee can work effectively around those pieces. That's my take.
So, Roger, maybe you can enlighten us on one aspect of this where the perpetual nature stumbling block issue may not be as big a factor, and that is on these Metro buyback properties. Because, my experience with the Metro buyback properties, particularly along 7 Mile Creek, is that you all identify a frequently flooded parcel. It's going to be a much better investment for the taxpayer to buy it rather than for the federal flood insurance program to continue to rebuild it every time it floods. So we buy it, we remove the structure. Often we take the structure all the way down to the concrete pad or even to the foundation.
Typically, we attempt to restore it to its natural condition, so we take out any kind of concrete pads or sidewalks or even shrubbery that would have surrounded a structure. We want to restore it. And there's been a lot, I think, still in perhaps in 7 Mile, certainly in Mill Creek, where there's a greenway, along Wimpole Drive, which will be featured in a book on flooding that comes out in April.
Richland Creek as well.
Richland Creek. So there are opportunities, and it seems like perhaps even a way to fill some gaps, to close some breaks in the greenway.
There are, obviously, working with the flood buyout properties has been very successful for greenways. The land use restrictions in these agreements prohibit putting in. So it doesn't allow us to develop greenways if we're entering into those agreements.
Okay.
We, building greenways, are placing these in conservation. Either we own the property, so it's becomes Metro Park property and essentially in perpetuity, or we place it in a conservation easement. So our mission is part of our mission is conserving that property, but also allowing public access and recreation. So the agreements, not just the perpetuity part of the agreement, but also what's allowed to take place in those easements.
But greenways are exempt from the buffer disturbance requirements in our stormwater manual.
But
So
not in these agreements for
I know, but
mitigation.
that is the disconnect we've got to bring together here. So if greenways if paved surfaces, the issue with paved surfaces, if greenways are exempt, paved greenways are exempt from a buffer disturbance variance from this committee, why can we not either work that in with part of this new amendment to this program, or B, provide ample mitigation or ample remediation for that paved surface along maybe in some other metro property within the watershed?
So, well, the state puts that perpetual easement when you're going through a state program. Mm-hmm. Is it possible for us to have a local program where you buy credits from it, where you don't have to go to the state for permitting, that is intended for either stream restoration or for, greenways or parks, or, how do we disconnect the two?
Right.
Yeah, I think part of the disconnect is anytime you encapsulate a stream, you can't avoid dealing with the state and federal requirements.
For that, but running
But for buffer mitigation,
And we're not completely exempt from, if we are, if we're building a greenway at grade in a buffer, so we're not essentially coming in and really disturbing, that's one thing. If we're coming in and installing a bridge or a boardwalk, then we're going to be coming to this committee for a variance to be able to do that.
But that perpetual restriction wouldn't be tied to a crossing. It would be tied to stream mitigation credits that you're purchasing through the state. Is that correct?
So the credits, sorry, this is Lee, I'm going to jump in, apologies for interrupting. So the credits are not purchased from the state, they're purchased from the provider. But it is true that all impacts to jurisdictional waters of the state will require an ARAP permit. Whether or not it requires mitigation will depend upon the nature of the impact, and that would be part of the discussion during the application process. But one, and again, sorry for getting down in the weeds, but I do think it's very relevant to the discussion. What does the protection in perpetuity and land use restrictions mean? Okay, it means when you're setting up a mitigation site, whether a bank or an in lieu fee project site or even a PRN site, certain areas of the stream where impacts have already occurred, for instance, if there's a crossing, the area of that crossing is going to be excluded from credit generation. If there is a plan to put a crossing or something like that in the future, or future vegetation removal or management, that will be excluded. But nothing really lasts forever, right? And so I think it's an important point for what y'all are talking about, that if you come back in the future and you say, we need that stream crossing at Shelby Bottoms, and it happens to be in that mitigation site, What does that mean? Does it mean you can't ever do it? No, it does not mean that. It means we have to go through a little bit of a tedious process for removing that, modifying the land use restrictions, taking that into account. But essentially what it will mean is you have to mitigate not just for the impact that you're now having within that mitigation site, but also for the impact that it was offsetting. And so, at a minimum, double mitigation at some new site. It does not mean you'll never, ever be able to build that crossing ever again. Okay, so I think that based on what y'all are talking about, the constraints on future land use may not be as severe as what you think they are. Now, granted, at some point, you can do enough incremental impacts that the site as a whole is no longer viable as a mitigation site, and you will lose all mitigation value for that stream reach. Okay, but there is an avenue where, say right now, we don't think we need to impact this part of the stream on Shelby Bottoms, but in 10 years, we decided we need to come back and put in a new golf cart crossing. There's a method for doing that, okay? It's just very expensive, because one thing I think is we can all bet on is that as expensive as it is to buy credits from the private sector at present, it is not going to be cheaper in the future.
All right.
Well, that was a very important piece that we need to drill down on. And we really need to learn more about what the tedious process means if we do want to create that hiking bridge in an area that was previously mitigated in a metro parks or properties, whichever metro government owned land it is, and maybe make it less tedious so that it becomes a receiver of these credits versus, again, the credits going out of county, out of watershed. That would be the intent.
I think that's one of the hurdles. The second hurdle is just identifying these projects across the county. And the reason we haven't, there could be many reasons. I mean, it's just staffing, engineering, design of it, funding of it. So I don't know if those are things that we need to.
Mikhail, can you speak to that?
Yeah, we have identified projects with parks, and the Cumberland River Compact has been in conversations with Parks and the Corps and TDEC about these land use protection instruments. So this is a conversation that's been going on since before 2020. And I think that the hurdle has been represented correctly. It's the conflict between Metro Parks and their mission to preserve the parkland for people, and TDEC and the Corps and their responsibility to manage the resource in perpetuity so there's no net loss. And we've just had trouble getting over that hurdle. I think the idea of entering into legal documents that may signing legal documents, executing legal documents for land use protection with the caveat that, we may need to change it in the future. That's never been something that has been brought up in our conversation. And I don't know that anybody would feel comfortable signing a legal document for land use protection in perpetuity with a side conversation that if you need to change it, we'll work on it at that time. I'm not sure that you all would feel comfortable with that. And so that's new, that piece of information to me. But maybe that's the way forward. We've been working on it for a long time because we understand, that you all want the mitigation in the county, and we've heard you say that. I do have a quick question about, do people come to you with variance requests before or after they have their ARAP?
They usually come with their ARAP and their core permits, is our standard practice.
So for example,
And
I've got the list.
if they don't, we ask them to go back and get it and defer it until they do, so.
With exceptions like the airport where there's a need, and they can't have the time to wait.
Yeah.
Okay,
Yeah.
I've got the list of Davidson County ARAPs, in lieu, credit sales, mitigation credit sales, that have been purchased from us and where the mitigation occurred. And so it's hard, so if TDEC says, you know, you can have this ARAP, but you have to buy 500 credits, then say Century Farms buys the credits, and then they come to you, they've already purchased the credits, and they come to you and you say, but it has to be in Davidson County. There's a disconnect there because they can't come back to us and say, but it needs to be in Davidson County, because although we would love to do the mitigation in Davidson County, those projects right now aren't available. But we can tell you where the mitigation is happening, and it's Swamp Road.
And that's part of the problem we're trying to get ahead, trying to manage better here is try to change that sequence so it can be better run. You wanted to comment on the Metro Parks perspective I saw earlier.
Sure, and maybe I'll just zoom out a little bit on it. The Parks Department would love to do mitigation on park property, and we've had many, many conversations over the years with McHale and other entities to try and find a way to make it work, because certainly land conservation, restoration, environmental education is part of our mission. As Cindy said, recreation and public access is also part of our mission. So we have to be able to do both. We have conservation easements of different types on properties all over the county that place certain restrictions on what we can do. So it's not the perpetual nature of the agreement that is a problem per se. It is the restrictions on what we can do within that easement. So I think setting the golf course site aside for a moment, generally speaking, most of the sites that we would anticipate might be candidates for mitigation would be in areas where the only types of park improvements that we would likely be ever looking at would be trails, whether it's a paved trail or a primitive trail. So we're talking about very passive uses. And our perspective is also perpetual. We're thinking of what the community's needs might be 50 years or 100 years from now, and not to unreasonably restrict what we can do on those properties. So if there is a way to provide that flexibility on our waterways, then that's where it has always broken down in the past, because we've never gotten any traction on the possibility that there would be a reasonable and unburdensome path forward on getting a trail. Whether it is, and also to relocate trails. You know, the alignments of these streams also changes, even if it's inside an easement. And from time to time, that would mean that inevitably we would need to reroute a trail, even if it wasn't something that we chose to do. On the golf course project, we have been working with TDEC and Water Services and others to see if we can make that project work. So Metro Legal, Tom Cross, has been in conversations with TDEC's attorneys who have then sort of directed him to the Corps' attorneys. So that those conversations have been taking place with redlining of a potential agreement, sort of going back and forth between the attorneys. And none of that has been resolved or we haven't completely come to terms on it, but it looks like there may be some flexibility in there, according to the Corps' attorneys. So I do not fully understand the difference between a bank project and a permit permit responsible. I don't know the difference between the requirements around all of those, but, so the golf course may be a one-off. Also, it's on a golf course, which would probably be unusual. But if we can make it work on the golf course, that may be a good template for what we could perhaps, implement on a countywide basis.
Yeah, I think from our board's perspective, all of our applicants are going to want to pursue the banks instead of the permitting responsible approach, just because the difficulties that are there. And so we need to keep in mind both of them. I just know that most of our applicants are going to want to be able to write a check that somebody else executes versus having to identify the project, the location, go through the design, and because it adds a year. I mean, permitting responsible sites on ARAPs are 6 to 12 months for review, I would guess. Is that?
It depends on the quality of the proposal as it comes in.
And everybody's cheap, so they're trying to skim it and not give you a robust proposal.
And so
it takes longer.
Which lengthens the review time.
Well, and I could imagine if we were to develop a program, speaking for the Parks Department anyway, we would much rather work with a banking entity as opposed to multiple private developers to get the work done on our property.
Exactly. And I think that's one of our goals, is how do we identify those projects in the banking system, and how, we don't know what we're getting into. We just know the goals of keeping it in the county. And I don't know if we can achieve our goals, but if there's anything we can do to help, we want to help.
Yeah, go ahead.
If I may add, one of our urban projects is Stevens Valley, which is right on the county border with Williamson and Davidson County. So those credits aren't coming into Davidson County. But the easement pretty much aligns with the buffer requirements in Davidson County. So if you get large developments coming through, I think it's perfectly appropriate to encourage them to participate in compensatory mitigation by entering those streams into a restoration and, easement situation. They're not really losing anything because they have to, they're planning the site anyway. They know where they want the crossings. We can put breaks in the easements for those crossings, and they have to keep the buffer intact for stormwater regulations anyway. So if you get those large tracts of land, I think it's great to encourage them to participate in the program.
At Greenways, did you want to say something?
Yeah, I just want to expand a little bit on what Tim said about trails, because the Greenway system was initially started focusing on the major waterways in the city or in the county, and we've expanded that to smaller waterways. So our system, our plan to play master plan, calls for greenways to be built along the waterways, and those are paved trails. We have to, they have to withstand flooding, they have to be ADA compliant. We rarely cut a tree to build a greenway. I mean, we're very particular about how it's routed. But that system is focused initially and still on the waterway system. We're expanding now into the urban core as well. But so figuring out how to work with the kind of opposing issues here is really critical to continue the greenway system.
Do you all find yourselves staying more in the zone 2 these days?
Yes.
Yeah, that helps a lot.
Conservation, maintenance, tree canopy, all those things.
Yeah.
Is zone 2, is that a distance from the top of bank?
Yes, and it's an allowed mowable zone in our buffer codes.
And it's not measured from the top of bank, it's measured from the floodway.
Well, if
Which
there
is
is measured
floodway.
from, depending on drainage acreage, it could just be a zone 1. If it exceeds a certain acreage, there's a zone 2 as well. And if it's a floodway, it's 75 feet from the floodway versus from the top of bank.
Yeah.
And very often, our easements for a greenway will go beyond the floodway and the buffers.
Yeah. All right, so we've been talking about this almost an hour and a half. So This has been really useful. I mean, if we don't have these conversations, like Mikhail said, she'd already learned something she didn't know. And often that's what happens when you get a group of people together in this kind of open, transparent forum. New information tends to come out. You learn something, opportunities begin to emerge, and then you act on it. If we don't act on this as good faith individuals, legislative bodies tend to. And we all know what happens when legislative bodies do things without our input, right? Sometimes we get something we don't like, sometimes we get something better. I was told a long time ago, it's a whole lot better to walk in with a proposal that most of you agree to than it is to have a proposal given to you from the top down. So, but on the mitigation banking side, often it's really more an opportunity for potential mitigation banking managers to take on that situation. The state's already said, and parks have said, they have good experiences with mitigation banks. Parks would like to deal with one entity rather than multiple entities like a mitigation bank. So there may be other nonprofits in Davidson County or other, forgive this phrase, quote, entrepreneurially minded nonprofit organizations that might want to pursue trying to figure this out for Davidson County. And so it's an opportunity, for an individual organization to step in and come up with a creative solution. So but the bottom line is I think this conversation, it'd be a good idea if this conversation continued. Today's my last day. So, so I can't really dictate what or promote what we should do because I'm not going to be here next month. But I do want to say I really appreciate every one of you coming out. I mean, in this day and time, it takes a lot of courage to come out and state your opinions in a recorded public format and sound intelligent and not break the law. And do it the right way, because they'll definitely take you to court these days. But this has been very useful, and I really appreciate you all being good citizens and, above all, great professionals. This has been very helpful. So does anybody else have any other questions or comments? Do we need to hear a little bit more about the airport situation, or are y'all ready to move on?
I don't think we do. I think it was more of a lesson learned on what we're trying to correct than how it unfolded.
But I guess one thing I'm thinking, I like solutions. I like getting to solutions on things, and we have a lot of challenges that have been discussed here. And I'm not going to say that we have a defined solution for what we're trying to do. There's mitigation needs, there's needs for land, and as much as we want to have the mitigation happen in the county, I would kind of challenge us as a commission to think more broadly, like was discussed by TDEC, of thinking more about the watershed approach, because that may open up more opportunities for mitigation that truly benefits the community, even if the mitigation's happening upstream in another county, that would benefit our county and the waterways in this jurisdictional boundary that we have. But, so I think, like Mikhail was talking about, she knows the locations. She can speak to locations of where some of the opportunities are that may not be within the county boundaries. And I would like us to be open-minded moving forward and kind of consider those while we are working in these constraints that exist. While other things may be happening in parallel, looking at creative solutions within the county to find mitigation opportunities through parks or otherwise. But as we move forward into this new year and have cases presented, maybe we need to be a little more lenient on considering mitigation outside the boundaries of Davidson County if they could improve the waters in Davidson County.
In the watershed, yeah.
Yeah.
All right. Any other comments?
Just one last one for me, just to, in the essence of to be continued, what are the next steps moving forward to carry this on? Is that a panel with the legal rep with Tom Cross, Metro Legal, Core, TDEC, as the redlining process is going on. I've heard that just now we need to be able to voice these same concerns to the group that is actually developing the rules that we're talking about, it seems, in order to have some effective change. Or there is another program that gets created, to your point, Chair, that is inter-metro. So from metro to metro, so from Metro Water Services infrastructure project to a Metro Properties or Parks project, is there a way to come up with an acceptable mitigation effort that we administer through this committee that puts this Tennessee Stream Bank program aside with all of the red tape that exists within it, and we come up with a guideline that updates our Metro Stormwater Management regs that is governmental specific, department specific, to say, okay, if Omohundro is going to wipe out 100 trees on that campus, then maybe we're okay with planting, 300 trees in Shelby Bottoms Park across the river, or some other mitigation effort that they've had on the docket for a long time, but have not been comfortable with the red tape that exists on the state and federal level. And that's just from a governmental agency to governmental agency program. Mm-hmm. Mm-hmm. So those are two pieces moving forward that I'd like to carry on as maybe a continuing series of this conversation. Yeah. And so that we can actually get something done related to this.
Yeah, I think it's definitely going to require an interagency collaborative effort. It really boils down to some leader being willing to kind of catalyze that effort, and some coalition of good faith participants being willing to volunteer to do it. There's many examples in the state of that having happened in years past. The Tennessee Interagency Wetlands Conservation Steering Committee, the West Tennessee Tributaries Steering Committee that led to the creation of the West Tennessee Tributary Basin Authority that we now know of today. By the way, that Basin Authority was created by the Tennessee General Assembly at the bequest of that interagency collaborative committee. And it was a very non-controversial bill. All the science was worked out before they got to the General Assembly. It was a bipartisan passage. And the current commissioner of TDEC was the first director of that agency. So, but it takes people of good faith willing to collaborate and launch it. And that usually starts with a leader, so, or a future chair. All right. Any other comments? Okay.
Did we address are there any other points that we take into consideration from the panel? Okay.
All right. We appreciate y'all very much. Appreciate your service to the state and the people of the county. Thank you. Thank you, sir.
Thank you for inviting us.
Thank you for coming. Very professional. Yeah, why don't we take about a 5-minute break, bathroom break, and then we'll come back for the last item of business, which will be the election of a new chair and vice chair.
fun because of like attorney-client privilege and all sorts of other stuff with Discovery, but it's great. I really like it.
So what is
They'll come when they're
So it's
ready.
called, Remarkable?
Yeah.
Okay, I've
and-
seen ads, so yeah.
And I just use it to take notes on basically. And
Okay.
it's greater than, like, I look at a screen all the time, so I kind of like having more of a actual notepad feel.
I'm a notepad person, but like with the new job, they're like, here's a rocket book. Cause you can,
I tried for a rocket book.
I'm not sure if it works for me.
Yeah.
I guess that's the thing, but
I like this better. I mean, this is more expensive than a rocket book. But, you know, it does at least keep things organized. And you can make like files within files to keep all of your notes organized if you want to, which is kind of nice.
that's cool.
It was a great Christmas present. Didn't ask for it, but I was like, oh, this is thoughtful and helps me with my job. What a good Christmas present from our boss.
It's awesome that several have showed up to like send Dot off.
What is our terms? Our terms are
2 or 3 years, I don't know. Is it 3? I don't know. I don't remember.
I just remember being like, this is a large commitment, but
Yeah. So my kids are like, really? We gotta get up. I didn't volunteer so much. I'm like, are you serious? Like, come on, it disrupts your life. Like,
yeah. Well, that's I always like to be involved with either a nonprofit or like some. So this has been really helpful to learning.
yes. I feel like I'm learning a lot too.
Yeah.
So, yeah.
Which also will bleed into my job a bit, and so it's like a win-win. When I was a young attorney.
Okay, so we probably ought to reconvene so we can get everybody home or back to their jobs.
Let's give this back.
Yes. And Mikhail wanted you all to have access to that stuff.
Is it meant for everyone? Or
Yeah, get a photograph of it. Okay, all right, so we're going to call our Stormwater Commission meeting of January 3rd back to order. So we've just got a couple of items of business left. We're going to have a little discussion about, from individual commission members concerning whatever they would like to say. So that's all I know. So.
You want to go first? Okay. I've got a few things prepared. First, I worked with Metro Council office to write a resolution that honors Mr. Galbraith for his service on the Stormwater Management Commission. That's been accepted by council as of the last council meeting, and on January the 16th, Mr. Galbraith will be present at the council meeting to have that formally acknowledged before the Metro Council. So I would like to read that resolution, and then you're also going to have this read at the council meeting. This is Resolution 2023-152, a resolution honoring Dodd Galbraith for his service on the Stormwater Management Commission, whereas after 15 years on the Stormwater Management Commission, Dodd Galbraith's service will end in January 2024, and whereas he was first appointed to the commission by Mayor Carl Dean in January 2009, he was reappointed by Mayor Dean in 2012, by Megan Berry in 2016, and by Mayor John Cooper in 2020. And whereas in 2017, Mr. Galbraith was elected as vice chair of the commission and was elected as chair of the commission in 2019. And whereas Mr. Galbraith has worked closely with Metro staff during his service over the past 15 years and assisted on legislation regarding the makeup of Metro boards and commissions to ensure that qualified individuals are selected as members of the Stormwater Management Commission and securing a name change for the commission to better reflect its status. And whereas, in addition to his service on the commission, Mr. Galbraith is professor at Lipscomb University and the director of the Institute for Sustainable Practice, the South Sea's first comprehensive academic sustainability program. And whereas, in addition to his service on the Stormwater Management Commission, Mr. Galbraith serves as the chair of the Tennessee Board of Water Quality, Oil, and Gas, representing environmental interests. And whereas, while serving 2 governors of both parties, he led the passage of 6 state laws to manage surface and groundwater use, designate a state scenic river, and restore natural rivers and wetlands. He also co-chaired one of the nation's first state environmental justice plans. And whereas Mr. Galbraith has received 2 statewide leadership awards, and in 2020 was awarded the Robert Sparks Walker Lifetime Achievement Award from the Governor and Commissioner of the TDEC Department of Environment and Conservation. And whereas Mr. Galbraith has dedicated his over 40-year career to sustainability and conservation, it is fitting and proper that the Metro Council honor his service to Nashville and Davidson County. Now therefore be it resolved by the Council of the Metropolitan Government in Nashville and Davidson County. The Metropolitan County Council hereby goes on record on expressing its deepest appreciation and gratitude to Dodd Galbraith for his invaluable contributions to the Stormwater Management Commission and wishes him success in his future endeavors. This resolution shall take effect from and after its adoption, the welfare of the Metropolitan Government in Nashville and Davidson County requiring it.
I wondered why they wanted me to go to the council. That's usually on the front end, not the back end.
So everybody is invited to that council meeting. It's on January the 16th at, I think, 6 o'clock. I'll send out an email as well. We're also going to be having a cocktail hour, correct?
I work at Lipscomb, by the way. That will be Jesus' first miracles.
Mocktail hour.
Mocktail hour at Taylor, Nashville, and it will be on January the 18th at 4:30. So we'll send out an invite to that as well. So
thank you very
anybody
much.
is welcome. Anybody watching, you're also welcome to come to that.
I appreciate it very much. Thank you.
Well, Logan, you really stole my thunder on some of the pieces with this legislation, and it was essentially going to be 2 or 3 points. One was, Dot, I think you've been an outstanding servant to our community, and that has been outlined here in this resolution. I'm glad it's going to be recorded. 2, I think you've chaired this committee in a manner that in a manner that has been a great example for due process. And not only a great example for me to build from, but the rest of the commission and future commissioners to learn and go back and watch the tapes and see how it's really done. So big shoes to fill on my part and all of our parts as this commission evolves. And then my third and final point is I think you should be noted on the record as coining the term sponginess as it relates to the protection of our watersheds. It's been fun hearing you pontificate in a meaningful way to applicants as it relates to disturbances to our buffers. And therefore, I have a gift for you to recognize that term, and it is an organic sponge. So I'd like to present this to you as a token of our appreciation. And in fact, to carry your legacy forward and for all commissioners to remember the importance of keeping our watershed spongy, I have sponge for everybody. So
I'm particularly impressed. These are real sponges. They're not human made. These are natural made, by the way. So
that's right.
These come from the ocean.
These come from the earth and the ocean. That's it. That's exactly so right. Thank you for your service.
Thank you.
Dodd.
I appreciate that very much.
That's all I have.
Well, is there anything else you needed to do? You had to do?
I don't know if anybody else has anything to say.
Don't want to force any comments on anybody. Nope, I'm not looking to be weepy-eyed on camera anymore.
Right.
So.
Well, you have a note for me, but I also mentioned in my note personally about you've been a voice for the habitats and the creatures and the flora and fauna of our county that have not had a voice here, working to protect them and protect the waters of our community. And I really appreciate that. And your leadership has come from heart, and that matters. And we've had some trying, difficult cases that you've handled very well professionally, but also with some candor. And it's going to be hard to think of all the different ways to ask for letters and information from council members and others. You had creativity along the way, as well as professionalism and true heart in leadership. So thank you.
All right. Well,
Chair,
yes,
Chair.
Mr. Lindsay.
On behalf of the staff, I just wanted to say to you that the years of your service to this group just about matches my years of service to Stormwater. Your knowledge of our regulations, our ordinances, in essence, the Metro Code, and the way you handle your leadership position with this commission has given the staff a good level of comfort that when a trying case comes before this group, that you handle it well, and it gives us a level of comfort that a proper hearing will be held of items before this group. So thank you very much for your service.
I appreciate it, Roger. Thank you very much. Okay, now can we get up beyond this?
No,
As
no,
much
you
as I
cannot.
appreciate it. Okay. I've known Michael, I think, the longest.
I was going to say, if I might add on to what Roger said, maybe add a personal note. I think I was looking around the room. I may have known Dodd longer than anybody else here because we both worked for TDEC together back in the day. Way too many years to mention, but I would just like to thank him for his service. Consider him a friend, I think, and just have always been impressed with his level of professionalism and his ethics and how he always seems to handle difficult situations in a very professional and diplomatic manner. And I think I think that's a good example for a lot of us that are having to deal with tough circumstances each and every day. And I just appreciate your leadership in that regard. And I will miss you, but hope to see you around in all the sustainability circles as you continue your role with Lipscomb. Thank you.
Thank you, Michael. I appreciate it. And you are a friend. Okay. Is that enough? I would like to say just a couple of things. I just want to leave it better than I found it. And primarily because we all have kids, and I have kids, and that's who we're doing this for. The resource serves them, and the great thing about being a citizen of this country is that boards like this represent we the people. And we're here not to have one prevailing singular point of view. We're here to have a diversity of views, because that diversity of talent and insight and differences of opinion are what serve we the people best. And that is the applicants who are trying to make a living and trying to pay their bills have a right to an efficient, clearly transparent, clearly understandable due process without having to guess all the time what's expected of them. Some things have to be resolved by us, but one of my goals was just to make sure that we did things in a way that gave the applicants some certainty of the process. Maybe not certainty of the outcome, but certainty of the process. And one of the things I'm most proud of that we talked about a few years ago was that our variances have been reduced by about half, I think, over previous years. And I really believe a lot of that has to do with communicating clarity to the applicant. Because if they're coming here, something needs to be resolved. If they're not coming here, they know what to do. The ordinances speak for themselves. And I'm glad that we've created some clarity and reduced some time that people have to go through to deal with confusion. And then, but most importantly, I as was implied earlier, I really do care about the resource. Gary Myers, the former head of the Tennessee Wildlife Resources Agency, who is the author of the Tennessee waterfowl management plan for the entire United States. Told me one time, he said, Dodd, it's about the resource. You know, the ordinance is the resource, the floodplains, the buffers, the streams, the chemical quality of our waters, the quantity of the water. You know, that resource is why we're here. And that's why Davidson County, I think, thrives as well as it does, because we've done a good job. Because of Metro Stormwater staff, you know, when you get to work with the provost of the National Floodplain Managers Association, you know you're dealing with talent. And every week, you know, somebody made the comment about my professionalism. I learned that from Paula Key. She was the first technical secretary of this committee when I joined. And I always marveled at how efficient and professional and how well prepared she was. And Logan has continued that. And I just really appreciate that. And I know Stephen Mishu was here earlier, and I appreciate others being here that I have talked to on the side. I've got a former student here that, as one board member said, you couldn't tell from my votes that he was my former student. But we try to be fair to everybody, and so I really appreciate everybody coming out. And I very much enjoyed this, and I appreciate your comments. So with that, a torch gets passed, and we have a couple items of business that we need to take care of. So the first item of business is, and I also want to also say I appreciate the Metro Council doing what they've done. I didn't realize that was in the works, and I'm very much appreciative of that. So at this time, we need to take care of the election of a new chair, and since there's a chance that our current vice chair may be nominated for chair. If that is the case, then we'll also need to vote on a vice chair. So we'll have two positions if things go the way they usually go. But it's totally up to you all how you want to handle it. So do we have any nominations from the floor for chair of the Metro Stormwater Commission?
I'll nominate Vice Chair Sandhu.
All right, we have a nomination for the vice chairman to be the chairman. Do we have any other nominations? Or do we have a motion regarding the nomination process? Such as in nominations cease or
I'll make a motion to elect the vice chair to chair.
All right, so we have a motion to elect the vice, that nominations essentially cease and that we elect our current vice chair as our chair. Is there a second?
Second.
All right, we have a second. Is there any discussion on the motion as properly seconded? Seeing none, all those in favor say aye.
Aye.
All those opposed? Any abstentions? You are now the chairman of the Metro Stormwater Commission.
Thank you, and thank you, commissioners. That's a great honor, and I have big shoes to fill here, so acknowledge that.
So I'll just say as a member now of the Metro Stormwater Commission that congratulations. I saw you coming. You know, one of the things I meant to say earlier was that this time for me was selected because I didn't want to break the 19 or 20-year record of the previous chair. I just didn't feel like doing that. And secondly, I felt really good about the members, all of the members who are here at this table. I mean, this is a really good group of people, and you all will do a better job than any of us in the past. I'm confident of that. So congratulations, Chair. So I'm going to turn it over to you to elect the vice chair.
Great. All right. First order of business. Thank you. Well, commissioners, do we have any nominations for vice chair? I know in the past we've, how did we do that? Did we write it on a piece of paper, or we just? I think we did. Okay. All right. I'll open the floor for any nominations.
I would nominate Jay Fulmer if he would be willing to serve.
All right. Jay nomination made to Mr. Fulmer and accepted graciously by Mr. Fulmer. We have a motion.
I'll make a motion to elect Jay Fulmer as vice chair.
Excellent. Any discussion?
I will second the motion.
Properly seconded. All right, all in favor?
Aye.
Aye.
Aye. Any noes? Okay, good. Motion carries. Very good. Congrats, Jay. Looking forward to that and your continued service. All right. Any other items of business? Logan?
Nope. There's some food back there.
There is. We
Everybody's
do
there.
have coffee and some I'll say brunch at this point in time for those that are hungry after these long meetings, and looking forward to seeing folks at the mocktail cocktail reception here in a week or two. So with that, there's no other business.
Let's let former chairman do the motion to adjourn.
Absolutely.
Oh, that's fair
Thank
enough.
you.
Thank you. I move, Mr. Chairman, Sandu, that we adjourn.
Very good. If we have a second?
Second.
All in favor? Aye. Motion carries. Thank you, Chair Dodd.
Thank you. Thank you all.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.